Mr. Barrasso, Mr. Bennett, Mrs. Blackburn, Mr. Blumenthal.
Marky's here.
Mr. Booker, Mr. Bozeman, Mr. Braun, Mrs. Brett, Mr. Brown, Mr. Budd, Ms. Butler, Ms. Cantwell, Mrs. Capito, Mr. Carden, Mr. Carper, Mr. Casey, Mr. Cassidy, Ms. Collins, Mr. Coons, Mr. Cornyn, Ms. Cortez Masto, Mr. Cotton, Mr. Kramer, Mr. Crapo, Mr. Cruz,
Yes.
Mr. Daines, Ms. Duckworth, Mr. Durbin, Ms. Ernst, Mr. Fetterman, Mrs. Fisher, Mrs. Gillibrand, Mr. Graham, Mr. Grassley, Mr. Haggerty, Ms. Hassan, Mr. Hawley, Mr. Heinrich, Mr. Hickenlooper, Ms. Hirono, Mr. Hoven, Mrs. Hyde-Smith, Mr. Johnson, Mr. Kane, Mr. Kelly, Mr. Kennedy, Mr. King, Ms. Klobuchar, Mr. Langford, Mr. Lee, Mr. Lujan, Ms. Lummis, Mr. Manchin, Mr. Markey, Mr. Marshall, Mr. McConnell, Mr. Menendez, Mr. Merkley, Mr. Moran, Mr. Mullen, Ms. Murkowski, Mr. Murphy, Mrs. Murray, Mr. Ossoff, Mr. Padilla, Mr. Paul, Mr. Peters, Mr. Reed, Mr. Ricketts, Mr. Risch, Mr. Romney, Ms. Rosen, Mr. Rounds, Mr. Rubio, Mr. Sanders, Mr. Schatz, Mr. Schmidt, Mr. Schumer, Mr. Scott of Florida, Mr. Scott of South Carolina, Mrs. Shaheen, Ms. Sinema, Ms. Smith, Ms. Stabenow, Mr. Sullivan, Mr. Tester, Mr. Thune, Mr. Tillis, Mr. Tuberville, Mr. Van Hollen, Mr. Vance, Mr. Warner, Mr. Warnock, Ms. Warren, Ms. Warren, Mr. Welch, Mr. Whitehouse, Mr. Wicker, Mr. Wyden. Mr. Young.
A quorum is present pursuant to Rule 3 of the Rules of Procedure and Practice in the Senate. When sitting on impeachment trials, the hour of 1:00 p.m. having arrived and a quorum having been established, the Senate will proceed to consideration of the articles of impeachment against Alejandro N. Mayorkas, Secretary of Homeland Security.
Madam President.
Majority Leader is recognized.
At this time, pursuant to Rule 3 of the Senate Rules on Impeachment and the United States Constitution, the President pro tem emeritus, the Senator from Iowa, will now administer the oath to the President pro tem, Patty Murray.
Do you solemnly swear that in all things appertaining to the trial of impeachment of Alejandro N. Mayorkas, Secretary of Homeland Security, now pending, you will do impartial justice according to the Constitution and laws, so help you God?
I do. At this time, I will administer the oath to all senators in the chamber in conformance with the Article 1, Section 3, Clause 6 of the Constitution and the Senate's impeachment rules. Will all senators now stand and raise their right hands? Do you solemnly swear that in all things appertaining to the trial of the impeachment of Alejandro N. Mayorkas, Secretary of Homeland Security, now pending, you will do impartial justice according to the Constitution and laws, so help you God? The clerk will now call the names in groups of 4. Senators will present themselves at the desk to sign the oath book.
Ms. Baldwin, Mr. Barrasso, Mr. Bennett, Mrs. Blackburn. Mr. Blumenthal, Mr. Booker, Mr. Bozeman, Mr. Braun. Mrs. Britt, Mr. Brown, Mr. Budd, Ms. Butler. Ms. Cantwell, Mrs. Capito, Mr. Cardin, Mr. Carper. Mr. Casey, Mr. Cassidy, Ms. Collins, Mr. Coons. Mr. Cornyn, Ms. Cortez Masto, Mr. Cotton, Mr. Kramer. Mr. Crapo, Mr. Cruz, Mr. Daines, Ms. Duckworth. Mr. Durbin, Ms. Ernst, Mr. Fetterman, Mrs. Fisher. Mrs. Gillibrand, Mr. Graham, Mr. Grassley, Mr. Haggerty. Ms. Hassan, Mr. Hawley, Mr. Heinrich, Mr. Hickenlooper, Ms. Hirono, Mr. Hoven, Mrs. Hyde-Smith, Mr. Johnson, Mr. Kane, Mr. Kelly, Mr. Kennedy, Mr. King, Ms. Klobuchar, Mr. Langford, Mr. Lee, Mr. Lujan, Ms. Lummis, Mr. Manchin, Mr. Markey, Mr. Marshall, Mr. McConnell, Mr. Menendez, Mr. Merkley, Mr. Moran. Mr. Mullen, Ms. Murkowski, Mr. Murphy, Mrs. Murray. Mr. Ossoff, Mr. Padilla, Mr. Paul, Mr. Peters. Mr. Reed, Mr. Ricketts, Mr. Risch, Mr. Romney. Ms. Rosen, Mr. Rounds, Mr. Rubio, Mr. Sanders. Mr. Schatz, Mr. Schmidt, Mr. Schumer, Mr. Scott of Florida. Mr. Scott of South Carolina, Mrs. Shaheen, Ms. Sinema, Ms. Smith. Ms. Stabenow, Mr. Sullivan, Mr. Tester, Mr. Thune. Mr. Tillis, Mr. Tuberville, Mr. Van Hollen, Mr. Vance. Mr. Warner, Mr. Warnock, Ms. Warren, Mr. Welch. Mr. Whitehouse, Mr. Wicker, Mr. Wyden, Mr. Young.
Majority Leaders recognized.
Any senator who was not in the Senate chamber at the time the oath was administered to the other senators will make the fact known to the chair so that the oath may be administered as soon as possible to the senator.
The Sergeant at Arms will make the proclamation.
Hear ye, hear ye, hear ye. All persons are commanded to keep silent under pain of imprisonment while the Senate of the United States is convened as a court of impeachment to consider the articles of impeachment against Alejandro N. Mayorkas, Secretary of Homeland Security.
Madam President,
Majority Leaders recognized.
in a moment, I will ask unanimous consent to allow for debate time, to allow for Republicans to offer and have votes on trial resolutions, and allow for Republicans to offer and have votes on points of order. So, I ask unanimous consent that Senator Lee be recognized to offer a resolution that is the text of S-Res 624, the full Senate trial, that Senator Cruz be recognized to offer a resolution that is the text of S-Res 622, the trial committee, that there then be up to 60 minutes of debate on the resolutions, concurrently and equally divided between the two leaders or their designees, and following the use or yielding back of that time, the Senate vote on or in relation to the resolutions in the order listed, with no amendments to the resolutions in order. Further, that following the disposition of the trial resolutions, if they are not agreed to, Senator Schumer or his designee be recognized to make a motion to dismiss the first article of impeachment, that the motion be subject to only 7 points of order, that there be up to 60 minutes for debate, concurrently and equally divided on the motion to dismiss and the points of order, and that following the use or yielding back of that time, the Senate vote in relation to the points of order in the order raised and the motion to dismiss. Further, that if Senator Schumer or his designee makes a motion to dismiss the second article of impeachment, that the motion be subject to only one point of order, that there be up to 60 minutes for debate, concurrently and equally divided, on the motion to dismiss and the points of order, and that following the use or yielding back of that time, the Senate vote in relation to the points of order in the order raised and the motion to dismiss. Following that further disposition of Article 2, the Senate vote on the motion to adjourn the Court of Impeachment sine die. Finally, that there be up to 4 minutes for debate equally divided between the two leaders or their designees prior to each roll call vote, all without intervening action or debate.
Is there an objection?
Madam President,
Senator from Missouri.
reserving my right to object. To dismiss or table articles of impeachment against Secretary Mayorkas without a trial here today or in committee is an unprecedented move by Senator Schumer. Never before in the history of our republic has the Senate dismissed or tabled articles of impeachment when the impeached individual was alive and had not resigned. As Senator Schumer said in 2020, quote, "A fair trial has witnesses. A fair trial has relevant documents as part of the record. A fair trial seeks the truth. Nothing more, nothing less." I will not assist Senator Schumer in setting our Constitution ablaze and bulldozing 200 years of precedent. Therefore, I object.
Madam President.
Objection is heard.
Madam President, I raise a point of order that Impeachment Article 1 does not allege conduct that rises to the level of a high crime or misdemeanor as required under Article 2, Section 4 of the United States Constitution, and is therefore unconstitutional.
Under the precedents and practices of the Senate, the chair has no power or authority to pass on such a point of order. The chair, therefore, under the precedents of the Senate, submits the question to the Senate. Is the point of order well taken? The Republican leader is recognized. Clerk will call the roll.
Ms. Baldwin. Mr. Barrasso, Mr. Bennett, Mrs. Blackburn, Mr. Blumenthal, Mr. Booker, Mr. Bozeman, Mr. Braun, Mrs. Brett, Mr. Brown, Mr. Budd, Mrs. Capito, Mr. Cardin, Mr. Carper, Mr. Casey, Mr. Cassidy, Ms. Collins, Mr. Coons, Mr. Cornyn, Ms. Cortez Masto, Mr. Cotton, Mr. Kramer, Mr. Crapo, Mr. Cruz, Mr. Daines, Ms. Duckworth, Mr. Durbin, Ms. Ernst, Mr. Fetterman, Mrs. Fisher, Mrs. Gillibrand, Mr. Graham, Mr. Grassley, Mr. Haggerty, Ms. Hassan, Mr. Hawley, Mr. Heinrich, Mr. Hickenlooper, Mr. Rono, Mr. Hoven, Mrs. Hyde-Smith, Mr. Johnson, Mr. Kane, Mr. Kelly, Mr. Kennedy, Mr. King, Ms. Klobuchar, Mr. Langford, Mr. Lee, Mr. Lujan, Ms. Lummis, Mr. Manchin, Mr. Markey, Mr. Marshall, Mr. McConnell, Mr. Menendez, Mr. Berkeley, Mr. Moran, Mr. Mullen, Ms. Murkowski, Mr. Murphy, Mrs. Murray, Mr. Ossoff, Mr. Padilla, Mr. Paul, Mr. Peters, Mr. Reed, Mr. Ricketts, Mr. Risch, Mr. Romney, Ms. Rosen, Mr. Rounds, Mr. Rubio, Mr. Sanders, Mr. Schatz, Mr. Schmidt, Mr. Schumer, Mr. Scott of Florida, Mrs. Shaheen, Ms. Sinema,
I have nothing to do with that.
Ms. Smith, Ms. Stallion,
It was the memo that was saying they wanted to.
Mr. Sullivan, Mr. Tester, Mr. Thune, Mr. Tillis, Mr. Tuberville, Mr. Van Hollen, Mr. Vance, Mr. Warner, Mr. Warnock, Ms. Warren, Mr. Welch, Mr. Whitehouse, Mr. Wicker, Mr. Wyden. Mr. Young.
A quorum is present. The Senate is considering the point of order presented by the Majority Leader.
Madam President.
Senator from Texas.
Madam President, I rise to make a motion. The Majority Leader has argued that Secretary Mayorkas' defiance of federal immigration law and active aiding and abetting of the worst criminal invasion in our nation's history does not constitute a high crime or misdemeanor. He has presented no argument on that question. He has presented no briefing on that question, and the position is directly contrary to the Constitution, to the original understanding of the Constitution at the time it was ratified, and to the explicit position of the Biden Department of Justice as argued before the Supreme Court of the United States. The Majority Leader's position is asking members of this Senate to vote on political expediency to avoid listening to arguments. The only rational way to resolve this question is actually to debate it, to consider the Constitution and consider the law.
The Senator will recognize that the Senate is in a non-debatable position. The Senator has a right to offer his point of order, or his motion, but we are in a non-debatable position.
And my motion is to change that so that we can actually debate the law if senators care what the Constitution and law says. I therefore move that the Senate proceed to closed session to allow for deliberation on the question as required by Impeachment Rule 24.
Madam President.
Majority Leader.
In our previous consent request, we gave your side a chance for debate in public, where it should be, and your side objected. We are moving forward.
The question is on the motion.
Ask for the yeas and nays.
Is there a sufficient second? There is a sufficient second. The clerk will call the roll.
Ms. Baldwin. Mr. Barrasso. Mr. Bennett. Mrs. Blackburn. Mr. Blumenthal. Mr. Booker. Mr. Bozeman. Mr. Braun. Mrs. Britt. Mr. Brown. Mr. Budd. Ms. Butler. Ms. Cantwell. Mrs. Capito. Mr. Cardin. Mr. Carper. Mr. Casey. Mr. Cassidy. Ms. Collins. Mr. Coons. Mr. Cornyn. Ms. Cortez Masto. Mr. Cotton. Mr. Kramer. Mr. Crapo. Mr. Cruz. Mr. Daines. Ms. Duckworth. Mr. Durbin. Ms. Ernst. Mr. Fetterman. Mrs. Fisher. Mrs. Gillibrand. Mr. Graham. Mr. Grassley. Mr. Haggerty. Ms. Hassan. Mr. Hawley. Mr. Heinrich. Mr. Hickenlooper. Ms. Arono. Mr. Hoven. Mrs. Hyde-Smith. Mr. Johnson. Mr. Kane. Mr. Kelly. Mr. Kennedy. Mr. King. Ms. Klobuchar. Mr. Langford. Mr. Lee. Mr. Lujan. Ms. Lummis. Mr. Manchin. Mr. Markey. Mr. Marshall. Mr. McConnell. Mr. Menendez. Mr. Merkley. Mr. Moran. Mr. Mullen. Ms. Murkowski. Mr. Murphy. Mrs. Murray. Mr. Ossoff. Mr. Padilla. Mr. Paul. Mr. Peters. Mr. Reed. Mr. Ricketts. Mr. Risch, Mr. Romney, Ms. Rosen, Mr. Rounds, Mr. Rubio, Mr. Sanders, Mr. Schatz, Mr. Schmidt, Mr. Schumer, Mr. Scott of Florida, Mr. Scott of South Carolina, Mrs. Shaheen, Ms. Sinema, Ms. Smith, Ms. Stabenow, Mr. Sullivan, Mr. Tester, Mr. Thune, Mr. Tillis, Mr. Tuberville, Mr. Van Hollen, Mr. Vance, Mr. Warner, Mr. Warnock, Ms. Warren, Mr. Welch, Mr. Whitehouse, Mr. Wicker, Mr. Wyden, Mr. Young.
The nays are 51. The yeas are 49. The nays are 51. The motion is not agreed to. The pending order is the motion made by the Majority Leader on the point of order.
Madam President.
Senator from Louisiana.
Madam President, I have a motion. I think my motion takes precedent. Having heard Senator Schumer's serious allegations, which in my judgment are specious, about the constitutionality of these impeachment proceedings, we find ourselves in the awkward position, because we're in impeachment proceedings, of being unable to discuss in public the merits of Senator Schumer's claim, and at the same time, my Democratic friends have refused to go into closed session, so we can't discuss it. So for that reason, Madam President, I move we adjourn this court of impeachment immediately until 12 o'clock noon on Tuesday, April 30th, and I ask for the yeas and nays.
Is there a sufficient second? There is a sufficient second. The clerk will call the roll.
Ms. Baldwin. Mr. Barrasso. Mr. Bennett. Mrs. Blackburn. Mr. Blumenthal. Mr. Booker. Mr. Bozeman. Mr. Braun. Mrs. Britt. Mr. Brown. Mr. Budd. Ms. Butler. Ms. Cantwell. Mrs. Capito. Mr. Cardin. Mr. Carper. Mr. Casey. Mr. Cassidy. Ms. Collins. Mr. Coons. Mr. Cornyn. Ms. Cortez Masto. Mr. Cotton. Mr. Kramer. Mr. Crapo. Mr. Cruz. Mr. Daines. Ms. Duckworth. Mr. Durbin. Ms. Ernst. Mr. Fetterman. Mrs. Fisher. Mrs. Gillibrand. Mr. Graham. Mr. Grassley. Mr. Haggerty. Ms. Hassan. Mr. Hawley. Mr. Heinrich. Mr. Hickenlooper. Ms. Hirono. Mr. Hoven. Mrs. Hyde-Smith. Mr. Johnson. Mr. Kane. Mr. Kelly. Mr. Kennedy. Mr. King. Ms. Klobuchar. Mr. Langford. Mr. Lee. Mr. Lujan. Ms. Lummis. Mr. Manchin. Mr. Markey. Mr. Marshall. Mr. McConnell. Mr. Menendez. Mr. Merkley. Mr. Moran. Mr. Mullen. Ms. Murkowski. Mr. Murphy. Mrs. Murray. Mr. Ossoff. Mr. Padilla. Mr. Paul. Mr. Peters. Mr. Reed. Mr. Ricketts. Mr. Risch. Mr. Romney. Ms. Rosen. Mr. Rounds. Mr. Rubio. Mr. Sanders. Mr. Schatz. Mr. Schmidt. Mr. Schumer. Mr. Scott of Florida. Mr. Scott of South Carolina. Mrs. Shaheen. Ms. Sinema. Ms. Smith. Ms. Stabenow. Mr. Sullivan. Mr. Tester. Mr. Thune. Mr. Tillis. Mr. Tuberville. Mr. Van Hollen. Mr. Vance. Mr. Warner. Mr. Warnock. Ms. Warren. Mr. Welch. Mr. Whitehouse. Mr. Wicker. Mr. Wyden. Mr. Young.
On this vote, the yeas are 49, the nays are 51. The motion is not agreed to.
Madam President,
The Republican leader is recognized.
the Senate just swore an oath to do impartial justice according to the Constitution and the laws of our country. We swore to discharge a duty that is quite different from our normal work. As a court of impeachment, we're called not to speak, not to debate, but to listen, both to the case against the accused and to his defense. At this point, in any trial in the country, the prosecution presents the evidence of the case, counsel for the defense does the same, and the jury remains silent as it listens. This is what our rules require of us as well. But the Senate has not had the opportunity to perform this duty. The Senate will not hear the House managers present the details of their case against Secretary Mayorkas, that he willingly neglected the duties of his office and that he lied to Congress about the extent of that failure. Likewise, we will not hear the Secretary's representatives present the vigorous defense to which he's entitled. Our colleagues know that we are obligated to take these proceedings seriously. This is what our oath prescribes. It's what the history and precedent require. And I would urge each of our colleagues to consider that this is what the framers actually envisioned. The power of impeachment is one of the most delicate balances our constitutional system strikes with a portion of the American people's sovereign electoral authority. It purchases a safeguard against malpractice, and it gives the Senate the power and the duty to decide. This process must not be abused. It must not be short-circuited. History will not judge this moment well. Therefore, I move to table the point of order and ask for the yeas and nays.
Is there a sufficient second? There is a sufficient second. The clerk will call the roll.
Ms. Baldwin. Mr. Barrasso. Mr. Bennett. Mrs. Blackburn. Mr. Blumenthal. Mr. Booker. Mr. Bozeman. Mr. Braun. Mrs. Britt. Mr. Brown. Mr. Budd. Ms. Butler. Ms. Cantwell. Mrs. Capito. Mr. Cardin. Mr. Carper. Mr. Casey. Mr. Cassidy. Ms. Collins. Mr. Coons. Mr. Cornyn. Ms. Cortez Masto. Mr. Cotton. Mr. Kramer. Mr. Crapo. Mr. Cruz. Mr. Daines. Ms. Duckworth. Mr. Durbin. Ms. Ernst. Mr. Fetterman. Mrs. Fisher. Mrs. Gillibrand. Mr. Graham. Mr. Grassley. Mr. Haggerty. Ms. Hassan. Mr. Hawley. Mr. Heinrich. Mr. Hickenlooper. Mr. Rono. Mr. Hoven. Mrs. Hyde-Smith. Mr. Johnson. Mr. Kane. Mr. Kelly. Mr. Kennedy. Mr. King. Ms. Klobuchar. Mr. Langford. Mr. Lee. Mr. Lujan. Ms. Lummis. Mr. Manchin. Mr. Markey. Mr. Marshall. Mr. McConnell. Mr. Menendez. Mr. Merkley. Mr. Moran. Mr. Mullen. Ms. Murkowski. Mr. Murphy. Mrs. Murray. Mr. Ossoff. Mr. Padilla. Mr. Paul. Mr. Peters. Mr. Reed. Mr. Ricketts. Mr. Risch. Mr. Romney. Ms. Rosen. Mr. Rounds. Mr. Rubio. Mr. Sanders. Mr. Schatz. Mr. Schmidt. Mr. Schumer. Mr. Scott of Florida. Mr. Scott of South Carolina. Mrs. Shaheen. Ms. Sinema. Ms. Smith. Ms. Stabenow. Mr. Sullivan. Mr. Tester. Mr. Thune. Mr. Tillis. Mr. Tuberville. Mr. Van Hollen. Mr. Vance. Mr. Warner. Mr. Warnock. Ms. Warren. Mr. Welch. Mr. Whitehouse. Mr. Wicker. Mr. Wyden. Mr. Young.
The yeas are 49, the nays are 51. The motion to table is not agreed to. The motion before the Senate is the point of order. The question is on whether the point of order is well taken. Is there a sufficient second? There is. Clerk will call the roll.
Ms. Baldwin. Mr. Barrasso. Mr. Bennett. Mrs. Blackburn. Did she say no? Mr. Blumenthal. Mr. Booker. Mr. Bozeman. Mr. Braun. Mrs. Britt. Mr. Brown. Mr. Budd. Ms. Butler. Ms. Cantwell. Mrs. Capito. Mr. Cardin. Mr. Carper. Mr. Casey. Mr. Cassidy. Ms. Collins. Mr. Coons. Mr. Cornyn. Ms. Cortez Masto. Mr. Cotton. Mr. Kramer. Mr. Crapo. Mr. Cruz. Mr. Daines. Ms. Duckworth. Mr. Durbin. Ms. Ernst. Mr. Fetterman, Mrs. Fisher, Mrs. Gillibrand, Mr. Graham, Mr. Grassley, Mr. Haggerty, Ms. Hassan, Mr. Hawley, Mr. Heinrich, Mr. Hickenlooper, Ms. Hirono, Mr. Hoven, Mrs. Hyde-Smith, Mr. Johnson, Mr. Kane, Mr. Kelly, Mr. Kennedy, Mr. King, Ms. Klobuchar, Mr. Lankford, Mr. Lee, Mr. Lujan, Ms. Lummis, Mr. Manchin, Mr. Markey, Mr. Marshall, Mr. McConnell, Mr. Menendez, Mr. Merkley, Mr. Moran, Mr. Mullen, Ms. Murkowski, Mr. Murphy, Mrs. Murray, Mr. Ossoff, Mr. Padilla, Mr. Paul, Mr. Peters, Mr. Reed, Mr. Ricketts, Mr. Risch, Mr. Romney, okay. Ms. Rosen, Mr. Rounds, Mr. Rubio, Mr. Sanders, Mr. Schatz, Mr. Schmidt, Mr. Schumer, Mr. Scott of Florida, Mr. Scott of South Carolina, Mrs. Shaheen, Ms. Sinema, Ms. Smith, Ms. Stabenow, Mr. Sullivan, Mr. Tester, Mr. Thune, Mr. Tillis, Mr. Tuberville, Mr. Van Hollen, Mr. Vance, Mr. Warner, Mr. Warnock, Ms. Warren, Mr. Welch, Mr. Whitehouse, Mr. Wicker, Mr. Wyden, Mr. Young,
On this vote, the yeas are 51, the nays are 48. One senator responded present. The point of order is well taken, and the article falls.
Madam President,
Majority Leader is recognized.
I raise a point of order that Impeachment Article 2 does not allege conduct that rises to the level of a high crime or misdemeanor as required under Article 2, Section 4 of the United States Constitution and is therefore unconstitutional.
Madam President.
Under the precedents and practices of the Senate, the chair has no power or authority to pass on such a point of order. The chair, therefore, under the precedents of the Senate, submits the question to the Senate. Is the point of order well taken? Senator from Utah is recognized.
Madam President, as wrong as the Majority Leader was moments ago in making this particular point of order as to Article 1 of the impeachment articles. Article 1, remember, refers to the willful defiance by Secretary Mayorkas of the law. As wrong as he was in making that as to Article 1, and he was very wrong for the reasons articulated moments ago by the senator from Texas, he is even more wrong, far more so, with respect to Article 2, because Article 2 accuses him of knowingly making false statements. This is a violation of 18 U.S.C. Section 1001, a felony offense. If this is not a high crime and misdemeanor, what is? If this is not impeachable, what is? What precedent will be setting? We need to address this, and to discuss it, we need to discuss it in closed session. For that reason, Madam President, I move that the Senate proceed to closed session to allow for deliberation on this very consequential point of order that he's just made. That violates hundreds of years of Anglo-American legal precedent and understanding on the question required by impeachment Rule 24.
Question is, the question is on the motion. Is there sufficient second? There is. Clerk will call the roll.
Ms. Baldwin. Mr. Barrasso. Mr. Bennett. Mrs. Blackburn. Mr. Blumenthal. Mr. Booker. Mr. Bozeman. Mr. Braun. Mrs. Britt. Mr. Brown. Mr. Budd. Ms. Butler. Ms. Cantwell. Mrs. Capito. Mr. Cardin. Mr. Carper. Mr. Casey. Mr. Cassidy. Ms. Collins. Mr. Coons. Mr. Cornyn. Ms. Cortez Masto. Mr. Cotton. Mr. Kramer. Mr. Crapo. Mr. Cruz. Mr. Daines. Ms. Duckworth. Mr. Durbin. Ms. Ernst. Mr. Fetterman. Mrs. Fisher. Mrs. Gillibrand. Mr. Graham. Mr. Grassley. Mr. Haggerty. Ms. Hassan. Mr. Hawley. Mr. Heinrich. Mr. Hickenlooper. Mr. Rono. Mr. Hoven. Mrs. Hyde-Smith. Mr. Johnson. Mr. Kane. Mr. Kelly. Mr. Kennedy. Mr. King. Ms. Klobuchar. Mr. Langford. Mr. Lee. Mr. Lujan. Ms. Lummis. Mr. Manchin. Mr. Markey. Mr. Marshall. Mr. McConnell. Mr. Menendez. Mr. Merkley. Mr. Moran. Mr. Mullen. Ms. Murkowski. Mr. Murphy. Mrs. Murray. Mr. Ossoff. Mr. Padilla. Mr. Paul. Mr. Peters, Mr. Reed, Mr. Ricketts, Mr. Risch, Mr. Romney, Ms. Rosen, Mr. Rounds, Mr. Rubio, Mr. Sanders, Mr. Schatz, Mr. Schmidt, Mr. Schumer, Mr. Scott of Florida, Scott of South Carolina, Mrs. Shaheen, Ms. Sinema, Ms. Smith, Ms. Stabenow, Mr. Sullivan, Mr. Tester, Mr. Thune, Mr. Tillis, Mr. Tuberville, Mr. Van Hollen, Mr. Vance, Mr. Warner, Mr. Warnock, Ms. Warren, Mr. Welch, Mr. Whitehouse, Mr. Wicker, Mr. Wyden, Mr. Young.
On this vote, the nays are 49, the yeas are 49, the nays are 51. The motion is not agreed to. The pending business is the point of order raised by the Majority Leader.
Madam President.
Senator from Florida.
Madam President, as jurors, we have not had the time to review whether this point of order is contrary to the Constitution. Therefore, I move to adjourn the Court of Impeachment until 12 p.m. noon on Tuesday, April 30th, and ask for the yeas and nays.
Is there a sufficient second? There is a sufficient second. The clerk will call the roll.
Ms. Baldwin, Mr. Barrasso, Mr. Bennett, Mrs. Blackburn, Mr. Blumenthal, Mr. Booker, Mr. Bozeman, Mr. Braun, Mrs. Britt, Mr. Brown, Mr. Budd, Ms. Butler, Ms. Cantwell, Mrs. Capito, Mr. Cardin, Mr. Carper, Mr. Casey, Mr. Cassidy, Ms. Collins, Mr. Coons, Mr. Cornyn, Ms. Cortez Masto, Mr. Cotton, Mr. Kramer, Mr. Crapo, Mr. Cruz, Mr. Daines, Ms. Duckworth, Mr. Durbin, Ms. Ernst, Mr. Fetterman. Mrs. Fisher. Mrs. Gillibrand. Mr. Graham. Mr. Grassley. Mr. Haggerty. Ms. Hassan. Mr. Hawley. Mr. Heinrich. Mr. Hickenlooper. Ms. Hirono. Mr. Hoven. Mrs. Hyde-Smith. Mr. Johnson. Mr. Kane. Mr. Kelly. Mr. Kennedy. Mr. King. Ms. Klobuchar. Mr. Lankford. Mr. Lee. Mr. Lujan. Ms. Lummis. Mr. Manchin. Mr. Markey. Mr. Marshall. Mr. McConnell. Mr. Menendez. Mr. Merkley. Mr. Moran. Mr. Mullen. Ms. Murkowski. Mr. Murphy. Mrs. Murray. Mr. Ossoff. Mr. Padilla. Mr. Paul. Mr. Peters. Mr. Reed. Mr. Ricketts. Mr. Risch. Mr. Romney. Ms. Rosen. Mr. Rounds. Mr. Rubio. Mr. Sanders. Mr. Schatz. Mr. Schmidt. Mr. Schumer. Mr. Scott of Florida. Mr. Scott of South Carolina. Mrs. Shaheen. Ms. Sinema. Ms. Smith. Ms. Stabenow. Mr. Sullivan. Mr. Tester. Mr. Thune. Mr. Tillis. Mr. Tuberville. Mr. Van Hollen. Mr. Vance. Mr. Warner. Mr. Warnock. Ms. Warren. Mr. Welch. Mr. Whitehouse. Mr. Wicker. Mr. Wyden. Mr. Young.
On this vote, the yeas are 49, the nays are 51. The motion is not agreed to.
Madam President, a parliamentary inquiry.
Senator will state his parliamentary inquiry.
I appreciate that my friend from New York is eager to get this done with. But are we about to set a precedent that the allegation of a felony is not a high crime and misdemeanor?
That is not an appropriate parliamentary inquiry.
Madam President, I understand there are other ways for the majority to move this off the floor of the Senate, but I would urge my colleagues
Senator have a motion
to
that he wishes
understand
to make?
what we're doing.
Question is on the point of order raised by the majority leader.
Madam President.
The senator from Louisiana.
Thank you, Madam President. I have a motion, and it takes precedence. As I appreciate the majority leader's allegation, lying to the United States Congress is not a high crime and misdemeanor. You don't have to be Mensa material to know that it's not only a high crime and misdemeanor, it is a felony.
Would the senator please state his motion?
I will. Since we're not allowed to talk among ourselves about the absurdity of this, and my Democratic colleagues will not allow us to go into closed session to talk about the absurdity of this,
the Senate is
I
not
move
in a
that we adjourn until 12 o'clock noon on May the 1st, 2004, and I ask for the yeas and nays.
Is there a sufficient second? Would the senator modify his motion? I would ask the senator to modify his motion.
Madam President, 2004 would probably be preferable. But I'll accept a friendly amendment. We make it 2024.
The question is on the motion. Is there a sufficient second? There is a sufficient second. The clerk will call the roll.
Ms. Baldwin. Mr. Barrasso. Mr. Bennett.
Yes.
Mrs. Blackburn. Mr. Blumenthal. Mr. Booker. Mr. Bozeman. Mr. Braun. Mrs. Britt. Mr. Brown. Mr. Budd. Ms. Butler. Ms. Cantwell. Mrs. Capito. Mr. Cardin. Mr. Carper. Mr. Casey. Mr. Cassidy. Ms. Collins. Mr. Coons. Mr. Cornyn. Ms. Cortez Masto. Mr. Cotton. Mr. Kramer. Mr. Crapo. Mr. Cruz. Mr. Daines. Ms. Duckworth. Mr. Durbin. Ms. Ernst. Mr. Fetterman. Mrs. Fisher. Mrs. Gillibrand. Mr. Graham. Mr. Grassley. Mr. Haggerty. Ms. Hassan. Mr. Hawley. Mr. Heinrich. Mr. Hickenlooper. Ms. Arono. Mr. Hoven. Mrs. Hyde-Smith. Mr. Johnson. Mr. Kane. Mr. Kelly. Mr. Kennedy. Mr. King. Ms. Klobuchar. Mr. Lankford. Mr. Lee. Mr. Lujan. Ms. Lummis. Mr. Manchin. Mr. Markey. Mr. Marshall. Mr. McConnell. Mr. Menendez. Mr. Merkley. Mr. Moran. Mr. Mullen, Ms. Murkowski, Mr. Murphy, Mrs. Murray, Mr. Ossoff, Mr. Padilla, Mr. Paul, Mr. Peters, Mr. Reed, Mr. Ricketts, Mr. Risch, Mr. Romney, Ms. Rosen, Mr. Rounds, Mr. Rubio, Mr. Sanders, Mr. Schatz, Mr. Schmidt, Mr. Schumer, Mr. Scott of Florida, Mr. Scott of South Carolina, Mrs. Shaheen, Ms. Sinema, Ms. Smith, Ms. Stabenow, Mr. Sullivan, Mr. Tester, Mr. Thune, Mr. Tillis, Mr. Tuberville, Mr. Van Hollen, Mr. Vance, Mr. Warner, Mr. Warnock, Ms. Warren, Mr. Welch, Mr. Whitehouse, Mr. Wicker, Mr. Wyden, Mr. Young,
On this vote, the yeas are 49, the nays are 51. The motion is not agreed to. The pending motion is the point of order preferred by the Senate Majority Leader.
Madam President.
Senator from Kansas is recognized.
Madam President, I have a motion and it takes precedent. Before this body disrespects the Constitution any further, before we endanger our republic anymore, before we harm the reputation of this body anymore, I move to adjourn until 7 a.m. on November 6th, 2024, so the American people can at least have a vote on this impeachment trial.
Question is on the motion. Is there a sufficient second? Is there a sufficient second? There is a sufficient second. Clerk will call the roll.
Ms. Baldwin. Mr. Barrasso. Mr. Bennett. Mrs. Blackburn. Mr. Blumenthal. Mr. Booker. Mr. Bozeman. Mr. Braun. Mrs. Britt. Mr. Brown. Mr. Budd. Ms. Butler. Ms. Cantwell. Mrs. Capito. Mr. Cardin. Mr. Carper. Mr. Casey. Mr. Cassidy. Ms. Collins. Mr. Coons. Mr. Cornyn. Ms. Cortez Masto. Mr. Cotton. Mr. Kramer. Mr. Crapo. Mr. Cruz. Mr. Daines. Ms. Duckworth. Mr. Durbin. Ms. Ernst. Mr. Fetterman. Mrs. Fisher. Mrs. Gillibrand. Mr. Graham. Mr. Grassley. Mr. Haggerty. Ms. Hassan. Mr. Hawley. Mr. Heinrich. Mr. Hickenlooper. Ms. Hirono. Mr. Hoven. Mrs. Hyde-Smith. Mr. Johnson. Mr. Kane. Mr. Kelly. Mr. Kennedy. Mr. King. Ms. Klobuchar. Mr. Langford. Mr. Lee. Mr. Lujan. Ms. Lummis. Mr. Manchin. Mr. Markey. Mr. Marshall. Mr. McConnell. Mr. Menendez. Mr. Merkley. Mr. Moran. Mr. Mullen. Ms. Murkowski. Mr. Murphy. Mrs. Murray. Mr. Ossoff. Mr. Padilla. Mr. Paul. Mr. Peters. Mr. Reed. Mr. Ricketts. Mr. Risch. Mr. Romney. Ms. Rosen. Mr. Rounds. Mr. Rubio. Mr. Sanders. Mr. Schatz. Mr. Schmidt. Mr. Schumer. Mr. Scott of Florida. Mr. Scott of South Carolina. Mrs. Shaheen. Ms. Sinema. Ms. Smith, Ms. Stabenow, Mr. Sullivan, Mr. Tester, Mr. Thune, Mr. Tillis, Mr. Tuberville, Mr. Van Hollen, Mr. Vance, Mr. Warner, Mr. Warnock, Ms. Warren, Mr. Welch, Mr. Whitehouse, Mr. Wicker, Mr. Wyden, Mr. Young,
On this vote, the yeas are 49, the nays are 51. The motion is not agreed. The pending motion is the point of order raised by the Majority Leader.
Madam President.
Senator from Alaska.
Madam President, we seem to be in unprecedented territory here, so I have a parliamentary inquiry.
State your inquiry, please.
Madam President, has there been a successfully invoked point of order to dispose of an article of impeachment prior to opening arguments by the House managers?
The chair is not aware of any such occurrence.
Thank you, Madam President.
The pending,
unprecedented territory, as I mentioned.
Pending business is the point of order raised by the Majority Leader. The yeas and nays.
Madam President. Point of parliamentary inquiry.
Madam President.
The senator from Louisiana is seeking recognition. Will you state why you've asked for recognition, please?
I'm sorry, I couldn't hear you, Madam President.
Senator from Louisiana is recognized.
Thank you, Madam President. I have a motion, and it takes precedent.
State your motion, please.
Before we establish a precedent that lying to the United States Congress is not a felony,
the senator from Louisiana will state his motion.
and before we add a new chapter to the movie Pulp Fiction,
please,
I move that we go into executive session to at least allow us to talk about the breathtaking precedent we're about to establish here. And I ask for the yeas and nays.
The question is on the motion to proceed to executive session. The yeas and nays have been requested. Is there a sufficient second? There is a sufficient second. The clerk will call the roll.
Ms. Baldwin. Mr. Barrasso.
From 1900?
Mr. Bennett. Mrs. Blackburn. Mr. Blumenthal. Mr. Booker. Mr. Bozeman. Mr. Braun. Mrs. Britt. Mr. Brown. Mr. Budd. Ms. Butler. Ms. Cantwell. Mrs. Capito. Mr. Cardin. Mr. Carper. Mr. Casey. Mr. Cassidy.
How much more of this do we do?
Ms. Collins. Mr. Coons. Mr. Cornyn. Ms. Cortez Masto. Mr. Cotton. Mr. Kramer. Mr. Crapo. Mr. Cruz. Mr. Daines. Ms. Duckworth. Mr. Durbin. Ms. Ernst. Mr. Fetterman. Mrs. Fisher. Mrs. Gillibrand. Mr. Graham. Mr. Grassley. Mr. Haggerty, Ms. Hassan, Mr. Hawley, Mr. Heinrich, Mr. Hickenlooper, Ms. Arono, Mr. Hoven, Mrs. Hyde-Smith, Mr. Johnson, Mr. Kane, Mr. Kelly, Mr. Kennedy, Mr. King, Ms. Klobuchar, Mr. Langford, Mr. Lee, Mr. Lujan, Ms. Lummis, Mr. Manchin, Mr. Markey, Mr. Marshall, Mr. McConnell, Mr. Menendez, Mr. Merkley, Mr. Moran, Mr. Mullen, Ms. Murkowski, Mr. Murphy, Mrs. Murray, Mr. Ossoff, Mr. Padilla, Mr. Paul, Mr. Peters, Mr. Reed, Mr. Ricketts, Mr. Risch, Mr. Romney, Ms. Rosen, Mr. Rounds, Mr. Rubio, Mr. Sanders, Mr. Schatz, Mr. Schmidt, Mr. Schumer, Mr. Scott of Florida, Mr. Scott of South Carolina, Mrs. Shaheen, Ms. Sinema, Ms. Smith, Ms. Stabenow, Mr. Sullivan, Mr. Chester, Mr. Thune, Mr. Tillis, Mr. Tuberville, Mr. Van Hollen, Mr. Vance, Mr. Warner, Mr. Warnock, Ms. Warren, Mr. Welch, Mr. Whitehouse, Mr. Wicker, Mr. Wyden, Mr. Young,
On this vote, the yeas are 49, the nays are 51. The motion is not agreed to. The pending amendment is the point of order. Pending motion is the point of order raised by the majority leader.
Madam President.
The senator recognizes the Republican whip.
Madam President, I think it goes without saying that the Mayorkas Biden policies have led to the worst border crisis in American history. 7.6 million people apprehended, 1.8 million gotaways. Who knows how many unknown gotaways?
The senator is reminded that we are in a non-debatable position in the Senate.
The one thing we know is that 357 people were on the terrorist watch list apprehended coming into this country. We have a responsibility to hear these articles of impeachment.
The Senate will be in order.
And therefore, I move to table the Schumer point of order. And I ask for the ayes and nays.
Is there a sufficient second? There is a sufficient second. Clerk will call the roll.
Ms. Baldwin. Mr. Barrasso. Mr. Bennett. Mrs. Blackburn. Mr. Blumenthal. Mr. Booker. Mr. Bozeman. Mr. Braun. Mrs. Britt. Mr. Brown. Mr. Budd. Ms. Butler. Ms. Cantwell. Mrs. Capito. Mr. Cardin. Mr. Carper. Mr. Casey. Mr. Cassidy. Ms. Collins. Mr. Coons. Mr. Cornyn. Ms. Cortez Masto. Mr. Cotton. Mr. Kramer. Mr. Crapo. Mr. Cruz. Mr. Daines. Ms. Duckworth. Mr. Durbin. Ms. Ernst. Mr. Fetterman. Mrs. Fisher. Mrs. Gillibrand. Mr. Graham. Mr. Grassley. Mr. Haggerty. Ms. Hassan. Mr. Hawley. Mr. Heinrich. Mr. Hickenlooper. Ms. Hirono. Mr. Hoven. Mrs. Hyde-Smith. Mr. Johnson. Mr. Kane. Mr. Kelly. Mr. Kennedy. Mr. King. Ms. Klobuchar. Mr. Lankford. Mr. Lee. Mr. Lujan. Ms. Lummis. Mr. Manchin. Mr. Markey. Mr. Marshall. Mr. McConnell. Mr. Menendez. Mr. Merkley. Mr. Moran. Mr. Mullen. Ms. Murkowski. Mr. Murphy. Mrs. Murray. Mr. Ossoff. Mr. Padilla. Mr. Paul. Mr. Peters. Mr. Reed. Mr. Ricketts. Mr. Risch. Mr. Romney. Ms. Rosen. Mr. Rounds. Mr. Rubio. Mr. Sanders. Mr. Schatz. Mr. Schmidt. Mr. Schumer. Mr. Scott of Florida. Mr. Scott of South Carolina. Mrs. Shaheen. Ms. Sinema. Ms. Smith. Ms. Stabenow. Mr. Sullivan, Mr. Tester, Mr. Thune, Mr. Tillis, Mr. Tuberville, Mr. Van Hollen, Mr. Vance, Mr. Warner, Mr. Warnock, Ms. Warren, Mr. Welch, Mr. Whitehouse, Mr. Wicker, Mr. Wyden, Mr. Young,
On this vote, the yeas are 49, the nays are 51. The motion is not agreed to. The pending
President,
business is the
parliamentary
point of
inquiry.
order offered by the Senate Majority Leader.
Madam President, parliamentary inquiry.
Senator will state his inquiry.
Madam President, I inquire whether the actions we take today are creating a precedent on impeachments that would apply to all future impeachment actions in the Senate, including an impeachment of the President of the United States.
Impeachment precedents would apply in future impeachment hearings. The question is on the point of order. Is there a sufficient second? There is a sufficient second. The clerk will call the roll.
Ms. Baldwin. Mr. Barrasso. Mr. Bennett. Mrs. Blackburn. Mr. Blumenthal. Mr. Booker. Mr. Bozeman. Mr. Braun. Mrs. Britt. Mr. Brown. Mr. Budd. Ms. Butler. Ms. Cantwell. Mrs. Capicho. Mr. Cardin. Mr. Carper. Mr. Casey. Mr. Cassidy. Ms. Collins. Mr. Coons. Mr. Cornyn. Ms. Cortez Masto. Mr. Cotton. Mr. Kramer. Mr. Crapo. Mr. Cruz. Mr. Daines. Ms. Duckworth. Mr. Durbin. Ms. Ernst. Mr. Fetterman. Mrs. Fisher. Mrs. Gillibrand. Mr. Graham. Mr. Grassley.
Oh, I know that.
Mr. Haggerty. Ms. Hassan. Mr. Hawley. Mr. Heinrich. Mr. Hickenlooper. Ms. Arono. Mr. Hoven. Mrs. Hyde-Smith. Mr. Johnson. Mr. Kane. Mr. Kelly. Mr. Kennedy. Mr. King. Ms. Klobuchar. Mr. Langford, Mr. Lee, Mr. Lujan, Ms. Lummis, Mr. Manchin, Mr. Markey, Mr. Marshall, Mr. McConnell, Mr. Menendez, Mr. Merkley, Mr. Moran, Mr. Mullen, Ms. Murkowski, Mr. Murphy, Mrs. Murray, Mr. Ossoff, Mr. Padilla, Mr. Paul, Mr. Peters, Mr. Reed, Mr. Ricketts, Mr. Risch, Mr. Romney, Ms. Rosen, Mr. Rounds, Mr. Rubio, Mr. Sanders, Mr. Schatz, Mr. Schmidt, Mr. Schumer, Mr. Scott of Florida, Mr. Scott of South Carolina, Mrs. Shaheen, Ms. Sinema, Ms. Smith, Ms. Stabenow, Mr. Sullivan, Mr. Tester, Mr. Thune, Mr. Tillis, Mr. Tuberville, Mr. Van Hollen, Mr. Vance, Mr. Warner, Mr. Warnock, Ms. Warren, Mr. Welch, Mr. Whitehouse, Mr. Wicker, Mr. Wyden, Mr. Young,
On this vote, Senate will be in order. On this vote, the yeas are 51, the nays are 49. The point of order is well taken. Article 2 falls.
Madam President,
Majority Leader is recognized.
I move to adjourn the impeachment trial of Alejandro N. Mayorkas sine die, and I ask for the yeas and nays.
Is there a sufficient second? There is. There is a sufficient second. Clerk will call the roll.
Ms. Baldwin. Mr. Barrasso. Mr. Bennett. Did he say aye? Mrs. Blackburn. Mr. Blumenthal. Mr. Booker. Mr. Bozeman. Mr. Braun. Mrs. Britt. Mr. Brown. Mr. Budd. Ms. Butler. Ms. Cantwell. Mrs. Capito. Mr. Cardin. Mr. Carper. Mr. Casey. Mr. Cassidy. Ms. Collins. Mr. Coons. Mr. Cornyn. Ms. Cortez Masto. Mr. Cotton. Mr. Kramer. Mr. Crapo. Mr. Cruz. Mr. Daines. Ms. Duckworth. Mr. Durbin. Ms. Ernst. Mr. Fetterman. Mrs. Fisher. Mrs. Gillibrand. Mr. Graham. Mr. Grassley. Mr. Haggerty. Ms. Hassan. Mr. Hawley. Mr. Heinrich. Mr. Hickenlooper. Ms. Hirono. Mr. Hoven. Mrs. Hyde-Smith. Mr. Johnson. Mr. Kane. Mr. Kelly. Mr. Kennedy. Mr. King. Ms. Klobuchar. Mr. Langford. Mr. Lee. Mr. Lujan. Mr. Lummis. Ms. Lummis. Mr. Manchin. Mr. Markey. Mr. Marshall. Mr. McConnell. Mr. Menendez. Mr. Merkley. Mr. Moran. Mr. Mullen. Ms. Murkowski. Mr. Murphy. Mrs. Murray. Mr. Ossoff. Mr. Padilla. Mr. Paul. Mr. Peters. Mr. Reed. Mr. Ricketts. Mr. Risch. Mr. Romney. Ms. Rosen. Mr. Rounds. Mr. Rubio. Mr. Sanders. Mr. Schatz. Mr. Schmidt. Mr. Schumer. Mr. Scott of Florida. Mr. Scott of South Carolina. Mrs. Shaheen. Ms. Sinema. Ms. Smith. Ms. Stabenow. Mr. Sullivan. Mr. Tester. Mr. Thune. Mr. Tillis, Mr. Tuberville, Mr. Van Hollen, Mr. Vance, Mr. Warner, Mr. Warnock, Ms. Warren, Mr. Welch, Mr. Whitehouse, Mr. Wicker, Mr. Wyden, Mr. Young,
On this vote, the yeas are 51, the nays are 49. The motion is to agree to. The Senate, sitting as the court of impeachment, stands adjourned sine die. Majority Leader is recognized.
For the information of members, there are no further votes today. Now, I remind all members that we have very serious business ahead of us in the next few days, and we'll keep you informed as to schedule as things can get scheduled.
Republican Leader is recognized. The Senate will be in order. Would senators please take their conversations to the cloakroom?
Madam President, we've set a very unfortunate precedent here. This means that the Senate can ignore, in effect, the House's impeachment. It doesn't make any difference whether our friends on the other side thought he should have been impeached or not. He was. And by doing what we just did, we have, in effect, ignored the directions of the House, which were to have a trial. We had no evidence, no procedure. This is a day that's not a proud day in the history of the Senate.
If you want to find her, that would be.
Madam President.
Senator from Utah is recognized.
Madam President, I ask unanimous consent to enter into a colloquy with my Republican colleagues.
Without objection, so ordered.
Madam President.
Senator from Utah would hold. We do not have order in the Senate. I would ask all senators to take their conversations to the cloakroom as well as the staff. The senator would just hold till we have order, please. Senator from Utah is recognized.
Thank you, Madam President. What we've witnessed today is truly historic. This has never occurred. Nothing like this has ever occurred. You know, under Article 1, Section 3, Clause 6, we've been given a duty. We've been given the sole exclusive power to try all impeachments. Try all impeachments, not some of them, not just those with which we have happened to agree, not just those that we are happy that the House of Representatives undertook to prosecute, but all. The word try is also significant. It refers to the word trial. It's the same word. It's a proceeding in which the law and the facts are presented to finders of fact in front of judges in order to reach an ultimate disposition. In a criminal proceeding, it would be an ultimate disposition culminating in a verdict of guilty or not guilty. We were precluded from doing that job today, and we were precluded from doing so in a way that is not only ahistoric and unprecedented, but also counter-constitutional. Nothing could be further from the plain structure, text, and history of the Constitution than that. So let's look at the arguments that we would have heard, that we could have heard, that we should have heard today, had things unfolded as they were supposed to. Had things unfolded in a manner consistent with the oath that we took, first when we were sworn in as United States senators. We're all required to take the same oath to the Constitution when we did that, but also the oath that we took just a few hours ago in this very chamber, in this very case, to decide this case impartially. What would we have heard? Well, first and foremost, regardless of what you think about what a trial consists of or how different people might cleverly define the term, a trial will always, at a minimum, involve lawyers. And unless the person is proceeding pro se, you will always have lawyers there. Or at least one side will always be represented by lawyers, and in 99.9% of all cases, both sides will. You will hear from lawyers. We didn't hear that today. We didn't hear from the committee of individuals appointed by the House of Representatives to be the House impeachment managers or prosecutors. What else would you expect to hear? Well, you'd hear evidence. Evidence would be brought in. Sometimes trials in the Senate involve bringing in evidence in a documentary form. Other times you might have witnesses. We didn't have any witnesses. We didn't have any documentary evidence other than that which was charged. So let's talk about what was charged and what evidence we could have, would have, and should have heard had we done our job today. Well, the accusations in this impeachment trial can be fit into two categories. Category 1 is found in Article 1 of the Articles of Impeachment. Article 1 alleges that Secretary Mayorkas repeatedly, defiantly did the exact opposite of what federal law requires, namely that under myriad circumstances, 8 or 9 different statutory provisions that he violated, he was required to detain people whom he did not detain. But it's not just that he didn't do what the law required, he did the exact opposite of that. Instead of holding them until such time as they could be removed or alternatively adjudicated to have the status, whether under whether in the context of immigration parole or asylum or otherwise, he just released them. And in many cases, gave them work permits. We would have heard evidence about the fact that memoranda issued by Secretary Mayorkas within the Department of Homeland Security didn't just tolerate this result, they instructed this result. We would have heard evidence about the fact that at the outset of the Biden administration, Secretary Mayorkas, when asked what he would tell those traveling through the caravans, those paying many thousands of dollars per head, in some cases tens of thousands of dollars per head, to international drug cartels, instead of telling them don't do it, he said, maybe don't do it yet. Give us a few weeks before we're ready to receive you. Showing intention, a forethought, to facilitate the violation of federal law. We would have heard evidence about how he instructed his own department to violate those rules. We would have heard evidence about how directly contrary to federal law those things are and contrary to his own oath and his own duties. Now, as to Article 1, the Senate chose to dispose of this today by doing something it's never done in any context anywhere close to this, with a point of order that said as follows. The majority leader stood up, defiantly refusing to have the Senate perform its obligations, and raised the following point of order. He said, I raise a point of order that impeachment Article 1 does not allege conduct that rises to the level of a high crime or misdemeanor as required under Article 2, Section 4 of the United States Constitution is therefore unconstitutional. All right, let's talk about that for a minute. Now, had we been permitted to have a trial, alternatively, had we been permitted to go into executive session, alternatively, had we been permitted to go into closed session, as several of us moved today, we would have been able to hear arguments about this, about how wrong this is, because that's what you do when you have a trial. You hear evidence, you hear arguments from lawyers, and when someone makes a legal argument, as Majority Leader Schumer just did, you can consider their implications, and most importantly, consider whether or not the argument is right. Because when we're sworn in a trial of impeachment, our job is to serve as both finders of fact and adjudicators of law relevant to this case. We were denied that opportunity. So while we're exploring what we would have heard had we gone to trial, had we done our job, let's also explore what would have happened in a real trial had somebody made an actual motion and we've been permitted to do our job. Well, look, first and foremost, this is patently absurd to argue that a willful refusal to obey the law that one has a sworn solemn obligation to perform is somehow not impeachable. We don't have to look too far in order to find support for the conclusion that this is an illegitimate, unwarranted, unsubstantiated claim, one that's directly contrary to law. In fact, we don't have to look further than President Biden's own lawyer, the Solicitor General of the United States, who holds a special position within our federal government, performs functions that many people mistakenly associate with the Attorney General. But it is, in fact, the Solicitor General who is the United States government's chief appellate advocate and chief advocate before all proceedings in the U.S. Supreme Court. There was an exchange in a case argued last term in the Supreme Court of the United States called United States versus Texas. In that case, the Supreme Court heard arguments from the state of Texas about whether or not this administration's approach toward these same provisions of law is acceptable, whether or not they could challenge them. Now, unfortunately, the Supreme Court reached a conclusion with which I strongly disagree, and the Supreme Court concluded ultimately that the state of Texas lacks standing to challenge federal policy along the lines of what we're discussing today, notwithstanding the fact that it's conduct that inflicts substantial harm on the state of Texas and its residents. But the important part that we should have been able to argue here today is the exchange that occurred at oral argument between Justice Kavanaugh and Elizabeth Prelogar, Solicitor General of the United States, in her capacity as Solicitor General, as the Biden administration's chief appellate advocate and chief advocate before the United States Supreme Court. Justice Kavanaugh asked her a number of questions at oral argument, and on page 50 of that argument transcript, some of that discussion ensues. He asks the following: if a new administration comes in and says, we're not going to enforce environmental laws, we're not going to enforce labor laws, your position, I believe, is that no state and no individual and no business would have standing to challenge a decision to, as a blanket matter, not just not enforce those laws, correct? Here's what Solicitor General Prelogar says. Quote, that's correct under this court's precedent, but the framers intended political checks in that circumstance. You know, if an administration did something that extreme and said we're just not going to enforce the law at all, then the president would be held to account by the voters, and Congress has tools at its disposal as well. So this argument continues on to the next page, in which Justice Kavanaugh says, what are the exact tools that Congress has to make sure that the laws are enforced? And Solicitor General Prelogar answers. She says, well, I think Congress obviously has the power of the purse, and she goes on to explain how this is relevant. And then this goes on until we get to page 53, and then at page 53, Justice Kavanaugh jumps back in and says, I think your position is, instead of judicial review, Congress has to resort to shutting down the government or impeachment or dramatic steps of some sort or another. Solicitor General Prelogar responds by saying, well, I think that if those dramatic steps would be warranted, it would be in the face of dramatic abdication of statutory responsibility by the executive. So she just acknowledged exactly what has happened here, and she acknowledged that is exactly the moment at which the impeachment power becomes very relevant. Lest there be any doubt on that, this stuff was settled not just in 1789, when we adopted the Constitution, and when the framers used the language that they did. But remember, the framers were not operating in a vacuum. They were not writing on a blank slate. They were incorporating legal terminology that had been in use for centuries. In fact, Justice Story, in his treatise on the Constitution, discusses this very kind of thing and explains in section 798 of his famed treatise, written not so very long after the Constitution itself was written, that we got this stuff from England, that the British knew what impeachment meant, and they understood what would constitute a high crime or misdemeanor. In section 798, Justice Story acknowledges that there was precedent, there was an understanding at the time of the founding that recognized that you would have an impeachable offense if, among other things, a Lord Admiral would have neglected the safeguard of the sea. They didn't have a Homeland Security Secretary then, not in America, not in Britain. But this is really analogous. This is the exact same thing. Somebody who had a duty to do a certain thing under the law defiantly refused to do so. Those are arguments we could have and would have and should have heard today had we had an actual trial, had we been permitted even to go into executive session, or even to go into closed session. Why closed session? We don't want to have to do it in closed session. But you see, the standing rules of impeachment in this body preclude us from having this very kind of debate. So when Majority Leader Schumer made this argument, to the great shock and surprise of all of us, we wanted to warn the body and have this debate. He wouldn't let us do that. The Democrats voted us down. So that's That's Article 1 in a nutshell. Article 2 of the Articles of Impeachment, what do those get to? Well, those are interesting because those deal with false statements, knowingly false statements repeatedly made by Secretary Alejandro Mayorkas to Congress. To Congress, as it's performing its oversight responsibilities. He lied to Congress according to the allegations of the Articles of Impeachment in Article 2. To my great shock, he was dead wrong as to Article 1. But if he was dead wrong as to Article 1, he was deader than a doornail, whatever that means. 10 times more dead as a doornail as to Article 2 than he was to Article 1. Why is that? Well, because they allege in Article 2 that Secretary Mayorkas knowingly made false statements. Knowingly making false statements is a felony offense. It's punishable as a crime, as a felony federal offense under, among other things, 18 U.S.C. Section 1001. It's routinely charged, prosecuted, and is the basis for lots of convictions for a felony offense. You can go to prison for a very long period of time for that. Now, for Chuck Schumer to argue...
Senator Yield.
Yes.
I just want to be able to be sure I understand, Senator. I thought I heard...
Microphone.
Madam President, I asked Senator Lee if he would yield to a question. I thought I heard Senator Schumer argue today that lying to the United States Congress was not a high crime or misdemeanor, and therefore could not be the basis for an article of impeachment. Did I hear that correctly?
That is exactly what he said. That is exactly what he said when he made this motion, because he stood up and he said, I raise a point of order that impeachment Article 2 does not allege conduct that rises to the level of a high crime or misdemeanor.
So, even though lying to the United States Congress is a felony, under the precedent that the majority leader and our Democratic colleagues established, it's not a high crime or misdemeanor? Is that what we did?
That is precisely what the precedent established today stands for. That is, we've effectively, by this vote that the Democrats forced through, not even allowing us to debate this, and this is why I raised a point of order this is why I made a motion that we go into closed session to discuss this, because we've now set a precedent that effectively, very arguably effectively immunizes from impeachment, making a false statement to Congress.
May I ask one more,
yes.
Senator?
Yes, please.
Well, I'm trying to follow the Senate Majority Leader's logic. What do you have to do to get impeached now? I mean, a felony is not sufficient. What's above a felony?
Well, let's see. Obviously, spreading what they deem misinformation on the internet might be a felony. I suppose at some point...
But it takes, as I understand it, Senator, you're a legal scholar, it takes more than a felony now.
A high crime or misdemeanor.
Yeah,
it takes more than a high crime or misdemeanor.
Who's on first? What's on second? I don't understand any of this, and I'm very, very worried and would like your thoughts or others' thoughts about the precedent that our Democratic colleagues, in their haste to sweep this under the rug, may have established.
Yep.
Will the gentleman from Louisiana yield for an adjunct question to his question?
With pleasure.
So the law says that lying to Congress is a felony. Since we're no longer using impeachment as a means to address someone who's lying to Congress, how does Congress prosecute or address someone who deliberately lies to Congress now that the Senate has swept away through this presidential action today the opportunity to use impeachment for that purpose? Thank you.
Yeah, and I'd love to respond to that point briefly, if I could. What we've done is to effectively immunize this against impeachability. Immunize making false statements. And going back to the original question, I don't know, maybe aggravated first-degree murder with heinous, atrocious, and cruel conduct as aggravators. Maybe that's still a high crime or misdemeanor. That remains to be seen. But keep in mind, particularly with the fact that they already set aside Article 1, and they've already said that that's out of bounds as well for impeachability. The Supreme Court has said pretty much nobody has standing to address that. What are we left with? And getting back to the question from Senator Lummis, this is a phenomenally dangerous precedent to have set here, specifically with regard to the false statements. Because what does that do to our oversight hearings, where we rely routinely on testimony provided under oath by cabinet secretaries and other administration officials? What does that do? What incentive structure does that create? What perverse incentives does that create for them to lie?
With this, Senator Gill?
Yes.
Are you aware, here's a question, are you aware of the fact that President Clinton was impeached? And one of the charges against him was lying under oath in a civil lawsuit. Are you aware of that?
Yes.
Okay, so you can be impeached for lying under oath in a civil lawsuit, but apparently you can't be impeached for lying to Congress about how you do your job. So here's what I'll give Senator Schumer the benefit of the doubt, Senator Kennedy. He's saying that the fact pattern here apparently doesn't rise to the level of high crime or misdemeanor, that we don't have a situation, it's a policy disagreement. We've taken a policy disagreement in the House and tried to turn it into impeachment. Well, here's a question for you, Senator Lee. Are you aware of the fact that 2 days ago, Secretary Mayorkas was asked about the parole of the man alleged to have killed Laken Riley, Mr. Ibarra? Why was he paroled and how he was paroled? Under the parole statute, 212D5, there's two ways parole can be granted. Unique humanitarian need, circumstance. Your mother's dying. Something's going on bad. You need to get into the country on a temporary basis, or special benefit to the United States. That means you're a witness in a probably cartel trial. Those are the only two reasons you can be paroled. And 2 days ago, no, yesterday, Secretary Mayorkas said he did not know why Mr. Ibarra was paroled. Which one of the two was it? This was a question from Congressman Bishop. He said, I didn't know. At the same time he said, I didn't know, I had the file, and it says, subject was paroled due to detention capacity at the Central Processing Center in El Paso, Texas. In the file, he was paroled because they didn't have any space for him. Senator Schumer, this is illegal. The Secretary of Homeland Security cannot just add a condition to a statute. The statute doesn't allow you to give parole because you're full. And the reason this man was given parole is not because of the statutory requirements, because we'd run out of space, because we got more illegal immigrants than we can handle, and the rest is history. He gets paroled, he goes to New York, he gets convicted of a crime, he goes to Georgia, and he's accused of murdering this lady. Seems to me that would be something we should argue over as to whether or not you should lose your job. Because you got a statutory requirement limiting your authority to parole people, and in your own file, Exhibit A, you paroled him because the place was full. This happened 2 days ago. So this gives kangaroo courts a bad name. This is a friggin' joke. We have a nation under siege. 1.9 million people have been paroled. Are you telling me they do an individual analysis on all the people? In November 2023, I asked him, Secretary Mayorkas, Do you do a case-by-case analysis? Senator, we comply with the law. So you're telling me of all the 240,000, the ones in front of us, you determine they meet the criteria of urgent humanitarian need or significant public benefit? And he said yes. This was in November, under oath to me, when I questioned, I don't believe you. I don't believe you're doing an individual analysis on this stuff. You're doing blanket parole and you're paper whipping this stuff. It turns out he gave false testimony to the Congress. Whether he lied or he's just doesn't know what he's doing, I don't know. You should be impeached either way. If you don't know what you're doing, you should be kicked out because you don't know what you're doing. But the man that we're talking about is the one charged with murdering this young lady who was going on a jog. If that's not important to the American people to find out how that happened, and should somebody be held responsible, what the hell is? You can talk about why we impeached Trump and Clinton. Was it worthwhile? Did it matter? Was it all political? You cannot say this is not important. To say that how he's doing his job is not important to the American people, tell that to the Riley family. This is not an academic debate. The policies of this administration being carried out by Secretary Mayorkas are illegal. The man charged with killing Laken Riley was illegally released into this country by DHS. That should be something we argue about in the Senate as to whether or not you keep your job. It's been swept under the rug. There will be an election in November. This is the only chance you have to get this right to the American people. We had a chance today to hold somebody accountable, finally, for all the rape and the murder and the drugs. The largest loss of life in America is fentanyl coming through the border for young people. How many more people have to be die, raped, or murdered before somebody is held accountable? We had a chance here, and our Democratic friends swept it under the rug because they're more concerned about the November election than protecting the American people. And this is a sad day for the Senate.
Law-trained kangaroos everywhere
are
going to be offended by the use of the term kangaroo court. In fact, the entire marsupial world will be offended by this. Senator Marshall, you have a question?
Yield. Yes. It certainly seems to me that today 51 of our friends across the aisle voted to not have a trial. Make note of this, that every person voted in that trial was a vote for an open border. It was a vote to tell Laken Riley's family that the life of their daughter didn't matter. It was a vote to tell the 250,000 families that lost a loved one to fentanyl it doesn't matter. But what struck me as the clock struck midnight here and we lost that vote, I feel like the Senate was gutted, that we lost part of our powers. You know, in high school we were taught, high school government, we were talked about checks and balances. And one of the checks and balances that the legislative branch had on the executive branch was this impeachment process. And I want to ask my colleague from Texas, why do I feel like I've just been gutted right now, like the entire Senate, that this body has been gutted of a power that we're never going to get back, that impeachment going forward may mean nothing? Am I wrong?
I'm sorry to say that my friend from Kansas is not wrong. In the 237 years of our nation's history, I don't know that there has been a more shameful day in the United States Senate than today. What we just witnessed was a travesty. It was a travesty to the United States Constitution, and it was a travesty to the American people. And it's important to understand why the Democrats did what they did. We're here on the Senate floor right now, but I want the record to reflect I'm going to do a very accurate count of the number of Democrats who are with us. That would be 0, other than the presiding officer, and somebody has to preside. Not a single Democrat senator chose to come to this floor and listen to one word of evidence. when it comes to the Constitution. The Democrats concluded that Joe Biden and Alejandro Mayorkas, defying federal law, ignoring the text of the statute, deliberately releasing criminal illegal aliens over and over and over again, that's just hunky-dory. You can't impeach him for that. Every Democrat just voted. By the way, every cabinet member, guess what? You've just been given a blank slate. Ignore the law. When Democrats are in charge of the Senate, the entire cabinet could ignore the law. It is no longer impeachable in Democrat wonderland when a member of the executive branch openly defies the law. By the way, every Democrat just voted that way. They didn't hear one word of argument. The majority leader didn't stand up and say, here's the reason why it's okay. No, he didn't present that argument. They didn't read a brief. Nobody wrote a brief. They didn't care enough to know what Senator Lee just laid out, that the Biden Department of Justice went in front of the U.S. Supreme Court and said if the executive defies the law, the answer is impeachment. The willingness of every Democrat to be blatantly hypocritical. Just last year, the Biden Justice Department said, no, you can't sue in court when we, the Biden administration, defy the law. The answer is impeachment. In like three-card money. Every Senate Democrat said, no, the answer is not impeachment. I don't know what it is. Actually, I do know what it is. There's only one answer left, which is everyone who is unhappy about the open border shows up in November, and to use the phrase, throw the bums out. Because if you're not willing to do your job, is there not one senator on that side of the aisle who cares enough to honor the Constitution? By the way, the second article they threw out said lying to Congress is not a high crime or misdemeanor, it's not impeachable. Now, as the senator from South Carolina pointed out, Bill Clinton was impeached for lying under oath. And you know what happened? And he was ultimately acquitted. But after a full trial where they heard the evidence, where the Senate did its job. By the way, one of the impeachment managers was Senator Graham, who presented that evidence right here on this floor. And you know what? Before Bill Clinton, there's a guy named Walter Nixon. You may not know who Walter Nixon is. Walter Nixon was a federal judge who was convicted of perjury. He was from Mississippi. He was convicted of perjury in front of a grand jury. And he was impeached. And it went to the Senate, and the Senate convicted him and removed him from the bench. So you want to know what the precedents were prior to today? You commit a crime, lying under oath, perjury, it is a high crime or misdemeanor that is impeachable. No more. Because understand the Democrats' rule here. This is not about the Constitution. None of them care. By the way, we repeatedly moved. Let's go into debate. Hear the other side of the argument. Nope. Look, the famous three monkeys, hear no evil, see no evil, speak no evil. That's just evil, what they did. They don't want to know because they don't care, because it's not about the Constitution. It's not about the law. It is about political expediency. But every bit as violent as what they did to the Constitution was, it's even more offensive what they did to the American people. Last year, 853 migrants died crossing illegally into this country. That's almost 3 a day. You go down to the southern border, you go down to Texas, which the Democrats don't bother to do because they don't care about the people dying. And you see photograph after photograph that Texas farmers and ranchers are finding of dead bodies on their property. Many of my colleagues here have been down there with me, have seen the elderly people the human traffickers have abandoned, have seen the pregnant women the human traffickers have abandoned, have seen the infants and toddlers left to die. The Senate Democrats just told the American people they don't give a damn about the bodies and the people who have died the last 3.5 years, and they don't give a damn about the people that are going to die next week. Next week, more migrants are going to die. When we brought 19 senators down to the border, we went out on a boat in the Rio Grande. We saw a man floating dead in the water. Senator Lee was there. Senator Kennedy was there. He had died that day. The Democrats just told the American people they don't care. When you go down to the border and you look at the children who've been brutalized, just about all of us here are parents. I will tell you, when you look in the eyes of a little girl or a little boy who's been abused by traffickers, and you see it, you see the pain, you see the agony of children trapped in sex trafficking, the Democrats just said they don't care. They won't hear the evidence, they don't care that it's deliberate, and they don't care that it'll happen next week, that it'll happen tomorrow. Tomorrow there will be children brutalized because of the Democrats' open border policies, and not a one of them cares. They don't care about the women who are repeatedly sexually assaulted. Again, when you look in the eyes of these women coming over, it's heartbreaking. And the Democrats just said, we don't care. And they don't care about the more than 100,000 Americans that died last year from drug overdoses. The highest in our nation's history. 70% of that is from Chinese fentanyl coming across our southern border. And the Democrats said, we don't want to hear about it. We're not interested in the Americans dying. You know what they also don't care about? They don't care about the criminals that are being released day after day after day. The Biden administration is releasing murderers and rapists and child molesters, and every week we see another story of somebody being killed, somebody being raped, another child being assaulted by illegal immigrants released by Alejandro Mayorkas and Joe Biden. How shocking is it that there wasn't one Democrat who says, you know, massive human suffering matters? We ought to hear the evidence. How shocking is it that there wasn't one Democrat? One! There are 51 of them on that side. Not a single one could screw up the courage to say, let's do our job, let's hear the evidence. How shocking is it that not a Democrat cares about the terrorists who are streaming across our southern border? The nation of Iran has called for jihad against America. Hamas has called for jihad against America. Hezbollah has called for jihad against America. And Joe Biden and the Democrats have put out a red carpet and said, if you want to murder Americans, come across our southern border, and we, the Democrats, will welcome you. Like many of us on this floor, I was in Washington, D.C. on September 11th, 2001. I remember the horror. I lost a good friend, Barbara Olson, who was in the plane that crashed into the Pentagon. I remember the smell of smoke and sulfur and burning. I remember the agony, and I remember the national unity that came after 9/11. As Democrats and Republicans came together, I don't know that I've ever been more proud of a president than when President George W. Bush stood on a pile of rubble with a bullhorn, talking to firefighters and New Yorkers, and one of the men in the crowd called out and said, we can't hear you, and he responded, well, I can hear you, and soon the whole world is going to hear you as well. We were as one. Today, not a single Democrat was able to mount up the courage to tell the majority leader, you know what, I don't want another 9/11 to happen. The House impeached Alejandro Mayorkas for, among other things, releasing terrorist after terrorist after terrorist. We ought to hear the evidence. I believe today we have a greater risk of a major terrorist attack on U.S. soil than at any point since September 11th. And every Democrat just told the American people it doesn't matter to them to hear the evidence. I appreciate my Republican colleagues who are here, who are willing to hear the evidence, willing to engage, willing to stand up and defend the American people. But you know what? The Democrats who aren't here, they aren't here because you know who's also not here? If you look up at the gallery, the reporters are all gone. A couple of folks in the back, I hope you're all right. But the reporters are absent. That's the Democrats' plan. What is fascinating, we're presenting arguments. Many of us, particularly those of us in judiciary, but many of us have presented those arguments over and over and over again in hearings. Not a Democrat argues on the other side. It's an issue unlike any other issue I know of in politics. Listen, if we're arguing about taxes, as Republicans, we say we should cut taxes. It's good for the American people. And you know what Democrats do? They stand up. We know their talking points. No, tax the rich. Okay, fine, we have a debate. We're talking about just about every issue. The Democrats will argue on the other side. They have their spin. What is fascinating? Where's Dick Durbin, chairman of the Judiciary Committee, standing up saying, no, it's not right that migrants are dying every day. No, it's not right that children are being assaulted every day. No, it's not right that women are being sexually assaulted every day. No, it's not right that they're releasing terrorists every day. They're not there. Not a Democrat is there. Why? Because you cannot defend it. I'll tell you, South Texas for 100+ years has been a Democrat region of our state. It is turning red with the speed of a freight locomotive.